everybody. Hello, welcome. Welcome in. Good to see you all. Good evening, everyone. Hello, welcome. Good to see you. Happy Thanksgiving Eve to you all. Hello. So actual facts. I've got I don't know, maybe 20 moderators that help me, and they just do the best that they absolutely can. They do try to give out warnings first, and they do try to just mute rather than block, but they just do the best that they possibly can. So we try to have a learning environment here and kind of keep control. Okay, well, just keep your eyes open. They usually give a warning, but we just kind of try to keep politics to the side as best as we can. So, yes, and I don't doubt it. Again, the moderators just do their absolute best. And sometimes, especially when we get hundreds of people in, which we always enjoy, sometimes they just have to go quick to get the trolls. So sometimes other people can accidentally get muted too. So sorry about that. But my moderators try so hard and they do an amazing job. So you can always feel free to message me and let me know, which lots of people do, and that's no problem whatsoever. But we just absolutely do our best here. Oh, definitely. Unsigned oath of, really? Open the records request. Okay, that's interesting. Very interesting. Yes, so good evening, everyone. I'm on just right at the time here, but we will, I'll wait here just a few minutes and let everyone get there. Oh, the judge walked out. Oh, goodness. You know, the day before Thanksgiving is a tough day. It's a tough day. It's a tough day for our paralegals, for our court staff, and then the Monday following Thanksgiving are really tough days. So for sure, those are some hard times. We do our best to muddle through, for sure. Oh, you can't message me, Kristen. That's crazy talk. Let me make a note. You should be able to message me. Oh my goodness. All right. Well, I'll double check and see what's going on with that. Let me make a note here. There we go. Madness, I tell you. Oh my gosh. Oh, yes. So I've got lots of very interesting things to talk about with everyone tonight, including ICWA. So I've got some short overviews and some original documents to share with everyone to kind of make sure that everyone has a bit of an understanding of how this goes on. Did I grab yellow sticks for tonight? Here's what I have, everybody. I'm unsure, okay? I have a little dry erase thing. I'm not sure if it's going to work. I'm going to try it, but I can write up the thing and then erase it. I'm not sure, everybody. I'm not sure about this crazy technology, but I'm going to try. Let me see what I can do. Hasn't kept its words. Oh, absolutely. So true. Absolutely. And I think it's really important that we talk about it, that we go into it. So I've got several treaties that I'll just kind of be doing some overviews on. What I have in front of me here is the the Indian Child, I was almost going to say Ohio, Indian Child Welfare Act, which was passed by Congress. And we have had some cases recently that have dealt with it, kept the structure in place. You have your quesadillas ready. Oh, love that. So I'll kind of go over that a little bit. I think it's really important, and it goes all the way back to the beginning of the settlers coming. So we've needed this in place for a long time. So I will be going through that. Oh, thank you very much. Thank you. Yes, I love cows. They're my comfort creature. They always make me happy. So I have a little bit of that going on. Oh, you've got popcorn. Love it. Yay. Jackie Coke. Oh my gosh, birthday cake. Oh, that sounds fantastic. So tonight, everybody, I do have, so I have the original Mayflower Compact, and I'll tell you the story behind that. This is, many see this as the very first original governing document for the United States. I should get a mini cal, way before the Constitution or the Articles of Confederation. So way before that. So I'll take you through that. And then I couldn't find the entire piece, but I did find the original beginning piece of President George Washington's proclamation, where he declared the third Thursday, sorry about that, the Thursday of November 26th to be devoted as a Thanksgiving. So I'll read through his original article, although I don't have the second piece of the column. I could only find the first column. So I've got that, very fun. Oh my goodness, yes. Nope, you're coming in just in time. I'm just getting started. And then I do have, and I'm not going to go through every word of it, but I do have the original treaty that was signed by the Cherokee Indians and the settlers here. So the first one that was set up with that particular tribe. So I will take you through that. Now it's hard to see that language, so I'm only going to read a few paragraphs, but I think it's valuable information. I think it's good insight to have on how they went about things. So that's pretty interesting, I thought. So we'll share that. And then let me get my final piece of paper here. Because originally, of course, we had a total of 350 treaties that were signed. So this particular treaty that I'll be talking about for the first few paragraphs will be the Cherokee tribe, and that's how they're referred to in the document. So any of the language I use is the language used in the document. So of course, I mean no offense, I'm just going within the language of the document. So we will kind of go into that. And I think it's interesting to see how they set out the land and how they set out what was going to be paid for and so on. So I think it's very interesting. So I have just a few pages of that to go through. So I think that'll be very interesting to kind of share with everybody here. But again, the language I do use is specifically the language of the law. So we have an entire area of the law called Indian Affairs, which we refer to it as Indian law. Now, of course, that would not be an appropriate way of addressing it, but I do have my entire research, and I've got treaties in here from the Navajos, from all over the place, a lot of our original case law that's come out as well. So we categorize it as Indian law. That's the title of it. So that's why I'm using that language, just to kind of give everyone a heads up on that. So let's go ahead and get started. I think one of the best ways to get started here would be to start with the Mayflower Compact. Yes, broken treaties. Yeah, and I would say water rights are probably the biggest issue that continues to go on. Of course, we have the Indian Child Welfare Act, which is incredibly important, but we continue to have a lot of problems. All right, everyone, so let's go ahead and get started. I'm not going to put a sticky note up on this because this is, well, I suppose I could. Hold on just one second here. Let me grab one. All right, so we'll get started here. Oh yes, of course. I think it's fascinating. So I thought, why don't I share it with everybody? At least I find it fascinating. Water is life, truly. All right, so this is, I'm writing out my thing here, the Mayflower Compact. Here we go. And this was signed in 1620. Now, it was only signed by the men, of course, because that's how that was. But we have, so of course, with the Mayflower Compact, there were 105 Puritans is what they called it, although technically that wasn't the name at the time. And They were in England. They were frustrated with the Church of England, but there were a whole bunch of them that just wanted a fresh new start on life. They went to Holland. They hung out in Holland. Then they were like, our kids are becoming too Dutch. So they picked their kids up, put them in a ship, and then off they went to the New World. So that's kind of like the 5-cent version of what happened here. So originally there were supposed to be 2 ships. One was the Mayflower, and then there was a second one. The second one had problems, so only the Mayflower went forward. 66 days they were at sea, very rough. They went north. I didn't print out a map because I don't think it really would make that much difference. Picture in your mind Greenland. That's how they came to the New World. So rather than the southern route with the pirates, they went north where it was cold, wound up landing then in the Massachusetts area eventually. They were supposed to be going into Virginia. So once they decided to go on to land, then they had all of the men on the ship sign this contract regarding how they were going to govern the situation. Originally, they had thought they were going to be in Virginia, so under Virginia law. But because that didn't pan out, because they were in Massachusetts, they were like, well, okay, we got to have another rule. So they put together this Mayflower Compact signed by the men. Now, of course, after the first winter, only half of them survived that first winter and then went forward. Now, Plymouth and the Mayflower are very important because it was the first official settlement. There were lots of other people that had come over before, but they had come over for trading purposes. There were lots of young men. There weren't families. They weren't really settling. They were there for entrepreneurship. So the Mayflower and Plymouth were a really big moment because it started our families. Speedwell, thank you, Frank. Yes, I had forgotten. Yes, poor Speedwell had some problems. So if you ever get a chance, if you're interested, you can go and look up the ships that were making the voyages at that time. And it is a very difficult journey. So that's why we even have this, because they had landed, and once they hit land after a very difficult 66 days, it took another 30 days before they figured out where they were going to be able to hop off the ship and go on to land. So once that happened, they wrote the Mayflower Compact. So let me read this to you. This is the original language. I have it printed out in an easier version over here. So again, this is very Puritan, so just keep that in mind. In the name of God, amen, whose names are underwritten, the loyal subjects of our dread sovereign Lord King James, by the grace of God of Great Britain, France, and Ireland, King, defender of the faith, having undertaken for the glory of God and the advancement of Christian faith and honor of our King and country, a voyage to plant the first colony in the northern parts of Virginia. Of course, they're not in Virginia, but they, that's fine. I hope everyone's able to follow along. I'm right here. In Virginia, do by these presents, solemnly and mutually in the presence of God and one another, covenant and combine ourselves together into a civil body politic for our better ordering and preservation and furtherance of the ends aforesaid, and by virtue hereof do enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and offices from time to time, as shall be thought most meet the convenient for the general good of the colony, unto which we promise all due submission and obedience, in witness whereof we have hereunto subscribed our names at Cape Cod the 11th. Again, if you're following along here, Cape Cod the 11th of November, in the year of the reign of our sovereign Lord King James of England, France, and Ireland, the 18th, and the Scotland, the 54th, Anno Domini, 1620. And then there are multiple signatures added to it. So This was signed by John Carver, William Bradford, Edward Winslow, William Brewster, Isaac Allerton, Miles Standish, John Alden, Samuel Fuller, Christopher Martin, William Mullins, William White, Richard Warren, John Howland, Stephen Hopkins, Edward Tilley, John Tilley, Francis Cook, Thomas Rogers, Thomas Tinker, John Rigsdale, Edward Fuller, John Turner, Francis Eaton, James Chilton, John Crackstone, John Billington, Moses Fletcher, John Goodman, Deggery Priest, Thomas Williams, Gilbert Winslow, Edmund Margison, Peter Brown, Richard Britteridge, George Soule, Richard Clark, Richard Gardiner, John Allerton, Thomas English, Edward Doty, and Edward Leicester. So there we have it, everybody. That's the Mayflower Compact. Very simple, just a little bit over 200 words, but it was the very first governing document in the United States, or what would become the United States later on. So there you have it. Now, of course, after barely surviving the first winter and many not surviving, didn't know John Goldman. Yes, John Goodman. I know, right? Not one woman. Nope, not a single woman was included. So now, of course, we know the problems, right? Without having the help of the indigenous people in the area, they would not survive. They had actually landed on an area where an entire tribe had been wiped out from the plague at that time. So the tribe had been wiped out and they had come in and were building on top of that land. So the indigenous people in the area came in. They had been used to some settlers because they had other people from Jamestown and various places that they had spoken to. There were a couple of the indigenous people that did speak English pretty well, so they started kind of negotiating back and forth. So through this negotiation, they were able to come to an agreement between the original indigenous people in the area and the settlers from the Mayflower. Now, keep in mind, this is probably the most peaceful time that ever existed between these two groups of people, was at the very beginning. Yes, so one of the biggest issues that happened when the Europeans came over onto the land was that they had brought lots of diseases that there was no immunity to. And so that actually knocked out 90%, over 90% of the population of the indigenous people in the area. So that was the single biggest issue that was going on with the indigenous people there. So, oh, hello, welcome. So anyway, at the beginning, they were working together. The indigenous people, the chief of a particular tribe was helping out and explaining how to grow food, how to sustain life. Meanwhile, the settlers then agreed to kind of help the indigenous tribes and offer protection as best as they could. So they had this mutually beneficial relationship in the very beginning, and that did last for a few years. As we all know, it did not last for that long. So yes, the first COVID-type pandemic, and I believe it was smallpox that took out that particular tribe, but I'm not 100% sure. All right, so after that, of course, we know there were lots and lots of problems between the colonists and the indigenous peoples. We had lots of problems after that, but that's how the original Mayflower settlers were with the indigenous people in the area. So I wanted to, before I get into the treaties, which I think is really important to kind of talk about, where everybody stood at that time, I do want to bring up that, of course, at this time, we didn't have the Articles of Confederation. We didn't have the Constitution. This is 150 years before the Constitution is when the Mayflower Compact was signed. So after the Mayflower Compact and time went on, of course, we had the Salem witch trials, which I spoke about last month. But then, as time went on, eventually we had multiple different times that we called at the time Thanksgiving celebrations. So we had this basically this gratitude meal time with a lot of the indigenous people regarding being able to live and survive through the winter. This took on a lot of different forms. It's, of course, it certainly is not what we picture and what we do now. There were a few peaceful times like that did occur, but, not very many. Mostly it did not occur. But at one point, George Washington, as president, had decided to mark the day. Now, he did mark it, and this is his Thanksgiving proclamation, and I will read through this. Again, I only have this first piece that was published. I don't have the second piece, but I will read through this. And then it wasn't really until Abraham Lincoln where it was really fully enacted. So it was kind of approached by President Washington, and then President Lincoln put it into place after he came in as president. So here is George Washington's Thanksgiving proclamation, and this is dated from October 3rd of 1789. Yes, there were lots of that. All right, so here we go. We're starting right here. Now, this is, I'm reading from a transcript again. This is what was submitted by the president here. And I only have this first piece. I just don't have the second piece of it. I could not find it anywhere, but here we go. I'll read through it. By the President of the United States of America, a proclamation. Whereas it is the duty of all nations to acknowledge the providence of Almighty God, to obey His will, to be grateful for His benefits, and humbly to implore His protection and favor, and whereas both houses of Congress have by their joint committee requested me to recommend to the people of the United States a day of public thanksgiving and prayer to be observed by acknowledging with grateful hearts the many signal favors of the Almighty God, especially by affording them an opportunity peaceably to establish a form of government for their safety and happiness. So that's kind of important. That's an important moment. Now, therefore, I do recommend and assign Thursday, the 26th of November, next to be devoted by the people of these states to the service of that great and glorious being, who is the beneficent author of all good that was, that is, and that will be, that we may then all unite in rendering unto him our sincere and humble thanks for his kind care and protection of the people of this country, previous to their becoming a nation, for the signal and manifold mercies and the favorable interpositions of his providence, which we experienced in the course and conclusion of the late war, for the great degree of tranquility, union, and plenty, which we have since enjoyed, for the peaceable and rational manner in which we have been enabled to establish constitutions of government for our safety and happiness, and particularly the national one now lately instituted, for the civil and religious liberty with which we are blessed, and the means we have of acquiring and diffusing useful knowledge, and in general for all the great and various favors which he hath been pleased to confer upon us. All right, we're here. So I just have one more paragraph after this one. Lincoln took inspiration from this. So he pulled his information from this. This was so inspirational to him. He decided to go forward and reinstitute it. So Washington started and then Lincoln backed it up. All right, so here we go. And also, yep, you got it. You're absolutely right, though. Lincoln came in and found this language to be very moving. And also that we may then unite in most humbly offering our prayers and supplications to the great Lord and ruler of nations, and beseech him to pardon our national and other transgressions, to enable us all, whether in public or private stations, to perform our several and relative duties properly and punctually, to render our national government a blessing to all the people by constantly being a government of wise, just, and constitutional laws, discreetly and faithfully executed and obeyed, to protect and guide all sovereigns and nations, especially such as have shewn kindness upon us, and to bless them with good government, peace, and concord, to promote the knowledge and practice of true religion and virtue, and the increase of science among them and us, and generally to grant unto all mankind such a degree of temporal prosperity as he alone knows to be best, given under my hand at the city of New York the 3rd day of October in the year of our Lord, 1789, signed George Washington. Yes, you got it. You got it. It was Lincoln that put it into full practice. So there you go, everybody. That's where the date came from. That's how it was chosen. So if anyone's wondering. Yes, and, George Washington was religious, but, religious then and religious now, they mean very different things. But, yeah, everybody was very religious at the time, according to the standards there. Everyone was religious back then. Oh my gosh. All right. So again, this is history. This is just history, everybody. It is what it is. So let's move forward then into a bit more current times. So that's George Washington there. And that takes us then into one of the treaties that I wanted to go through. So keep in mind, there were so many tribes. I mean, there were hundreds and hundreds of tribes all over the country. So there were over 350 treaties that were signed between the government and the indigenous people. So this is just an example of one of them here that I pulled. I mean, there of course are hundreds more, but this one happens to be with the Cherokee Nation at the time. So I thought it really gave a good idea, a good visual of how they set their treaties up. I do have multiple treaties. I looked at the Navajo one. I've looked at multiples, but this one I thought was pretty generalized. So yes. Oh, I mean, I will be the first to tell you these treaties have not been. And just as recently as just a few months ago, we've had some significant treaty issues. I'll be the first to tell you that, absolutely. So if you are curious and you want to look them up yourselves, I'm sure everybody will, right? We do have, again, an entire section of Indian Affairs. You can pull up Law and Treaties online. Volume 2 has all of the treaties. Now, this is over 2,000 pages, and it includes all of the treaties, every single treaty that was put into place. So, of course, I just printed what I thought was the most interesting to go through for tonight, but we start with the treaty with the Delawares in 1778. And what's really interesting, I think, is that all of these treaties are written, just in the same kind of format that our Constitution was written in, because that's how they drafted legal documents at that time. So they set out multiple articles and then sign it in the end. So this will, when I go through this next treaty, you'll see that there are several similarities between the structure of the treaties and the structure of the 7 articles in the Constitution. So here we go. Now, I did print out the actual copy of the document, but I'm going to read from the actual legal document so that we can see it, because I think it's too difficult to actually read it off of the screen here. But let me make sure I'm getting centered here. Here we go. Hello, welcome everybody. Yes, it's fun. I think it's important to kind of note the history a little bit as we go through so we can understand where we're coming from. When it comes to the law, everything comes from a starting point. If we figure out where the starting point is, then we're able to understand why the words were used. So let me go ahead. I'm just going to label this here so everybody knows. This is a treaty with the Cherokee is how they call it in the law. All right, so Cherokee. Cherokee. And then this was signed, written, agreed upon December 29th of 1835. So this was pre-Civil War. This is a great, yes, oh, absolutely, Deborah, absolutely. There's a lot of really amazing history here. Can you put a link up to these documents? Yes, and I think VC usually has a pretty good link tree going on with a lot of them, so for sure. Yes, it does, Lisa. That is exactly right. Merciless savages, yes. And there's, I believe that's actually within the Declaration of Independence is where that references. So here we go. Now, this is the actual first article, and in the law, so I'm actually going to start you here. In the law, we have kind of this preamble piece. So let me walk you through the preamble, and then we'll go into the articles itself. So here's the Treaty with the Cherokee, 1835. Articles of a treaty concluded at New Anchota in the state of Georgia. So that's very important. Again, this very early on, the 29th day of December of 1835 by General William Carroll and John F. Schermerhorn, commissioners on the part of the United States and the chiefs, headmen, and the people of the Cherokee tribe of Indians. So let me just get a little bit better of a point here. All right, here we go. So this will be the preamble, and then I'll switch us over into the articles. And I'll just read the first few articles to give you an idea of how they set this out. But I think it's interesting to see how their minds were working at the time. Whereas the Cherokee are anxious to make some arrangements with the government of the United States, whereby the difficulties they have experienced by residents within the settled part of the United States under the jurisdiction and laws of the state governments may be terminated and adjusted, and with a view to reuniting their people in one body and securing a permanent home for themselves and their posterity in the country selected by their forefathers, without the territorial limits of the state sovereignties, and where they can establish and enjoy a government of their choice and perpetuate such a state of society as may be most consonant with their views, habits, and condition, and as may tend to their individual comfort and their advancement in civilization. All right, just a moment. Tea break, everybody. Sorry. Okay. Oh, goodness. Oh, thank you. And whereas a delegation of the Cherokee Nation composed of Messrs. John Ross, Richard Taylor, Daniel McCoy, Samuel Gunter, and with the United States did on the 28th day of February of 1835 stipulate and agree with the government of the United States to submit to the Senate to fix the amount which should be allowed the Cherokees for their claims and for a cession of their lands east of the Mississippi River, and did agree to abide by the award of the Senate of the United States themselves, and to recommend the same to their people for their final determination. And whereas on such submission the Senate advised, quote, that a sum not exceeding $5 millions be paid to the Cherokee Indians for all their lands and possessions east of the Mississippi River, end quote. And whereas this delegation, after said award of the Senate had been made, were called upon to submit propositions as to its disposition to be arranged in a treaty, which they refused to do, but insisted that the same should be referred to their nation and their in general council to deliberate and determine on the subject in order to ensure harmony and good feeling among themselves. And whereas a certain other delegation composed of John Ridge, Elias Boudinot, Archia, Smith, S.W. Bell, John West, William A. Davis of immigration to the Cherokee country west of the Mississippi entered into propositions for a treaty with John F. Schermerhorn, commissioner of the part of the United States which were to be submitted to their nation for their final action and determination. And whereas Cherokee people at their last October council at Red Clay fully authorized and empowered a delegation or committee of 20 persons of their nation to enter into and conclude a treaty with the United States Commissioner then present at that place or elsewhere, and as the people had good reason to believe that a treaty would then and there be made. Hold on here. Let me center it again, everybody. Just a second. Here we go. Then and there be made, or at a subsequent council at New Anchota, which the commissioners, it was well known and understood, were authorized and instructed to convene for said purpose. And since the said delegation have gone on to Washington City with a view to close negotiations there, as stated by them, notwithstanding they were officially informed by the United States Commissioner that they would not be received by the President of the United States, and that the government would transact no business of this nature with them, and that if a treaty was made, it must be done here in this nation, where the delegation at Washington last winter urged that it should be done for the purpose of promoting peace and harmony among the people. And since these facts have also been corroborated to us by a communication recently received by the Commissioner from the government of the United States and read and explained to the people in open council, and therefore believing said delegation can affect nothing, and since our difficulties are daily increasing and our situation is rendered more and more precarious, uncertain and insecure in consequence of the legislation of the states, and seeing no effectual way of relief but in accepting the liberal overtures of the United States. And whereas General William Carroll and John F. Schermerhorn were appointed commissioners on the part of the United States with full power and authority to conclude a treaty with the Cherokees East and were directed by the President to convene the people of the nation in General Council at New Anchota and to submit said propositions to them with power and authority to vary the same so as to meet the views of the Cherokees in reference to its details. And whereas the said commissioners did appoint and notify a general council of the nation to convene at New Anchota on the 21st day of December, 1835, and informed them that the commissioners would be prepared to make a treaty with the Cherokee people who should assemble there, and those who did not come, they should conclude gave their assent and sanction to whatever should be transacted at this council, and the people having met in council according to said notice. Therefore, the following articles of a treaty are agreed upon and concluded between William Carroll and John F. Schermerhorn, commissioners of the part of the United States, and the chiefs and headsmen and people of the Cherokee Nation in General Council assembled this 29th day of December, 1835. All right, everyone, that was the preamble. So let me actually pull the document itself up so you can look through that as I read through these first couple articles for you. So we've got the preamble there. It doesn't seem like much negotiating really going on. I think we definitely had a difference in power in that situation, without a doubt. Oh, yes, indeed. All right, so here we go, everybody. I think this is close enough. You should be able to make out most of the words as I go through this, but it starts here with Article 1, and then this is Article 2 here, all right? So if you're looking for kind of some place marks to note where I'm at in the document, of course, this was an original handwritten document at the time, so here's Article 2 here. I just have a couple pages, so can kind of go through how they set the land out. All right, so here we go. Now, I do have a note down here of what it is in case anyone is wondering, so we can point that out. All right, Article 1, here we go. Article 1. the Cherokee Nation hereby cede, relinquish, and convey to the United States all the lands owned, claimed, or possessed by them east of the Mississippi River, and hereby release all their claims upon the United States for spoliations of every kind for and in consideration of the sum of $5 million to be expended, paid, and invested in the manner stipulated and agreed upon in the following articles. But as a question has arisen between the commissioners and the Cherokees, whether the Senate in their resolution by which they advised that a sum not exceeding $5 million be paid to the Cherokee Indians for all their lands and possessions east of the Mississippi River, have included and made any allowance or consideration for claims of spoliations. It is therefore agreed on the part of the United States that this question shall be again submitted to the Senate for their consideration and decision, and if no allowance was made for spoliations, that then an additional sum of $300,000 be owed for the same. So I'm right here, be owed for the same. So now I'll start with Article 2. Yes, $5 million. Yep. For all of the land east of the Mississippi. Okay, Article 2, everybody. Here we go. Whereas by treaty of May 6, 1828, and the supplementary treaty thereto of February 14, 1833, with the Cherokees west of the Mississippi of the United States, guaranteed and secured to be conveyed by patent to the Cherokee Nation of Indians for following tract of country, beginning at a point on the old western territorial line of Arkansas Territory, being 25 miles north from the point where the territorial lines crosses the Arkansas River, thence running from said north point south on the said territorial line, where the said territorial line crosses a Verdigris River, thence down said Verdigris River to the Arkansas River, thence down said Arkansas to a point where a stone is placed opposite the east or lower bank of the Grand River at its junction with the Arkansas, thence running south 44. All right, so I'm right here, thence running south 44th. So there's a stone apparently. All right, let's just double check that again. Okay, thence down said Arkansas to a point where a stone is placed opposite the east or lower bank of Grand River at its junction with Arkansas. So you can see how when we are talking about water rights, because a lot of the lands were set up based off of the water that was available there in the different rivers, you can see how whose rights to what water could really come into question when you have language like it's a stone in the river that meets another river. There's some problems there. So I'm just noting that, everybody. All right, so that's the first page. Now let's switch over here to the second page. Again, I am just reading the first couple of articles here. Let me just write this out again. A treaty with the Cherokee. And let me get the date correct here. December 29th of 1835. Yeah, in the rock, in the stone. Right. How shady the government is. Yes, indeed. Yes, indeed. I agree completely. 100% when it comes to our indigenous peoples. I agree completely. All right, so I'm going to continue on. So the last piece here was 44. So the next piece where they start back, this is the word degrees. So degrees west. Hopefully everyone can at least kind of see it a little bit. So degrees west, 1 mile, thence in a straight line to a point 4 miles northerly. from the mouth of the North Fork of the Canadian, thence along the said 4-mile line to the Canadian. Oops. So we've got the Canadian line here. That's what they're talking about, and that's another landmark that they're using in order to set out the boundaries. Thence along the said 4-mile line of the Canadian, thence down the Canadian to the Arkansas, thence down the Arkansas to the point on the Arkansas where the eastern Choctaw boundary strikes said river, and running thence with the western line of Arkansas Territory as now defined, to the southwest corner of Missouri, thence along the western Missouri line to the land assigned to the Senecas, thence on the south line of the Senecas to Grand River, thence up said Grand River as far as the south line of the Osage Reservation, extended if necessary, thence up in between said South Osage line, extended west if necessary, and a line drawn due west from the point of beginning to a certain distance west, at which a line running north and south from said Osage line to said due west line will make 7 million of acres within the whole described boundaries. In addition to the 7 millions of acres of land thus provided for and bounded, the United States further guarantee to the Cherokee Nation a perpetual outlet west and a free and unmolested use of all of the country west and of the western boundary of said 7 millions of acres as far west as the sovereignty of the United States and their right of soil extend. So again, because they hadn't gone into that area, it was easy to give it away, I think. Provided, however, that if the saline or salt plain of the western prairie shall fall within said limits prescribed for said outlet, the right is reserved to the United States to permit other tribes of red men to get salt on said plain in common with the Cherokees, and letters patent shall be issued by the United States as soon as practicable for the land hereby guaranteed. All right, so I'm right here. Profitable for the land hereby guaranteed. Yeah, so, oh my gosh. It's hard. It's hard to read through this, everybody, because it's pretty atrocious. It's pretty atrocious. Okay, here we go. Let me just write this out one more time, and then this will be the last article that I'll read through, and then I'll take you through ICWA here. So here we go. Again, this exact language in these treaties is what is debated in the U.S. Supreme Court on water rights, and was just debated just a few months ago. It is heartbreaking. It is absolutely heartbreaking. All right, here's the last piece. We're starting with the word and. And whereas it is apprehended by the Cherokees that in the above session there is not contained a sufficient quantity of land for the accommodation of the whole nation on their removal west of the Mississippi, the United States, in consideration of sum of $500,000, therefore hereby covenant and agree to convey to the said Indians and their descendants by patent in free simple the following additional tract of land situated between the west line of the state of Missouri and the Osage Reservation, beginning at the southeast corner of the same, and runs north along the east line of the Osage lands, 50 miles to the northeast corner thereof, and thence east to the west line of the state of Missouri. Thence with said line south 50,000 acres of land. But it is expressly understood that if any of the lands assigned the Quapaws shall fall within the aforesaid bounds, the same shall be reserved and accepted out of the lands above granted at a pro rata reduction shall be made in the price to be allowed to the United States for the same by the Cherokees. Okay, so there we go. Yes. So I don't have another exact copy of the treaty, but I think it would be valuable to go through the next article. So I think I will just continue on if that's okay with everybody, because we do get into some more specific language. So I'll just take you into the statute. Is there a map with this document? No, I don't have a map available. Usually I do, but the way that this was set out, I felt it was too confusing to try to explain. So I don't have a map. Let me see if I can I may have one here in my other materials that I have listed out. So, let me see. Okay, so let me see. This is the Navajo Nation. So I'm just trying to show you here what we're talking about, and my map isn't even going far enough over to get to the Missouri. So this isn't going to cover it. Yikes. Yeah, this is the Navajo Nation here. So, and you can see what a mess this is. 4 different states involved. I just don't have one here of, I've got the Choctaw Nation here. Oh, here's the law of the river. That's a very interesting law. We have a law that just sets out laws when it comes to different rivers in here. But no, I don't specifically have a map of this actual territory. Sorry about that, Suze. Sorry. I do have an entire presentation on the most recent U.S. Supreme Court case regarding water issues going on. I do have that up on my Tube of View channel. And the most important case is Arizona versus the Navajo Nation. Again, this was just decided last June. So if you are interested, this is a water rights case where they do go through and explain the key pieces of law, like the Winters case, setting out how they interpret different treaties. So if you are interested, I do have a YouTube video up. I did do a full live on that in the past, but I'm afraid I just don't have a map of this particular area. Yep, sorry about that. All right, here we go. Back into it one more time. Sure, oh, absolutely. And normally I would pull a map, but again, this one is so difficult to kind of understand. It's a good time. Well, it's difficult. It is difficult. Yeah, the water rights are very, very, they didn't have a map at the time. Their maps were a lot different, and they disagreed on the maps as well. They disagreed on the boundaries and how the boundaries were set. So it wasn't a very clear understanding by any means. All right, Article 3. So I'll go through Article 3 and Article 4 here before I move on to ICWA. Absolutely, Suze, absolutely. Yeah, and I thought about pulling a map, but I just felt with this, for the Cherokee Nation, because they are talking about west of the Mississippi, which was all uncharted territory. It was just blank land. So there weren't much for marks. There was no way to really determine where the lines were. All right, the United States also agrees that the lands above ceded by the treaty of February 14th of 1833 included the outlet, and those ceded by this treaty shall all be included in one patent executed to the Cherokee Nation of Indians by the President of the United States, according to the provisions of the Act of May 28th of 1830. It is, however, agreed that the military reservation at Fort Gibson shall be held by the United States. But should the United States abandon said post and have no further use for the same, it shall revert to the Cherokee Nation. The United States shall always have the right to make and establish such post and military roads and forts in any part of the Cherokee country as they may deem proper for the interest and protection of the same. I think that's very important to note. No matter what happens, military presence could always be brought into the territory. And the free use of as much land, timber, fuel, and materials of all kinds for the construction and support of the same as may be necessary, provided that if the private rights of individuals are interfered with, a just compensation therefore shall be made. And this is one of the most litigated pieces, is how much is just compensation. And then next will be Article 4 here. The United States also stipulate and agree to extinguish for the benefit of the Cherokees the titles to the reservations within their country made in the Osage Treaty of 1825 to certain groups here, their country made in that Osage Treaty. Sorry, everybody. Hold on. And for this purpose, they hereby agree to pay to the persons to whom, and for the same belong or have been assigned, or to their agents or guardians, whenever they shall execute after the ratification of this treaty a satisfactory conveyance for the same to the United States, the sum of $15,000 according to a schedule accompanying this treaty of the relative value of the several reservations. Yes, eminent domain. That this language is pulled from the Constitution. This was written after the Constitution, but that's the same language. Absolutely. And whereas by the several treaties between the United States and the Osage Indians, the Union and the Harmony Missionary Reservations, which were established for their benefit, are now situated within the country ceded by them to the United States, the former being situated in the Cherokee country and the latter in the state of Missouri, it is therefore agreed that the United States shall pay the American Board of Commissioners for Foreign Missions for the improvements on the same what they shall be appraised at by Captain George Vashon, Cherokee Subagent Abraham Redfield, and A.P. Chuteau, or such persons as the President of the United States shall appoint, and the money allowed for the same shall be expended in schools among the Osages in improving their condition. It is understood that the United States are to pay the amount allowed for the reservations in this article and not the Cherokees. Oh, all right. So, all right, well, I'm looking through Article 5 and 6. I feel like we need to end on a little bit lighter note. So let's push through here to Article 5 and 6, and we'll end on our perpetual peace piece. Article 5, the United States hereby covenant and agrees that the land ceded to the Cherokee Nation in the foregoing article shall in no future time without their consent be included within the territorial limits or jurisdiction of any state or territory, but they shall secure to the Cherokee Nation the right by their national councils to make and carry into effect all such laws as they may deem necessary for the government and protection of the persons and property within their own country, belonging to their people, or such persons as have connected themselves with them, provided always that they shall not be inconsistent with the Constitution of the United States and such acts of Congress as have been or may be passed regulating trade and intercourse with the Indians, and also that they shall not be considered as extending to such citizens and army of the United States as may travel and reside in the Indian country by permission according to the laws and regulations established by the government of the same. Article 6. Perpetual peace and friendship shall exist between the citizens of the United States and the Cherokee Indians. The United States agree to protect the Cherokee Nation from domestic strife and foreign enemies, and against intestine wars between the several tribes. The Cherokees shall endeavor to preserve and maintain the peace of the country and not make war upon their neighbors. They shall also be protected against interruption and intrusion from citizens of this United States who may attempt to settle in the country without their consent, and all such persons shall be removed from the same by order of the President of the United States. But this is not intended to prevent the residence among them of useful farmers, mechanics, and teachers for the instruction of Indians according to treaty stipulations. So, and I will stop there. I think that's a great place to stop before we move on to ICWA. Yes, so there we go, everybody. That kind of gives you some insight And this is very similar to how these treaties have all been put together. So if you are interested, again, you can go online. You can pull up any of the treaties that have been written between any of the tribes in the United States. And, you know, there's so many different tribes and so many different land descriptions. So it is a very interesting area of the law for those who are interested in it. I agree, it was traumatic. It's difficult. It's a difficult subject. It's a very difficult subject. It is, absolutely. All right, so let's talk about ICWA, everybody. Let's move on. Let's move on to ICWA. The Third Amendment didn't mean jack. Right, yes, true. The Third Amendment did not apply, was not applicable. Yeah. We make a lot of mistakes, everybody. I mean, we make huge mistakes, and we've made huge mistakes, and we continue to make mistakes. You know, the best we can do is acknowledge and try to work on it and do better. So we have this is the Indian Child Welfare Act of 1978. This was something that they had been trying to get passed for a very long time. One of the original issues, of course, that happened even before the Mayflower came were that there were settlers or people from Europe that came and kidnapped different indigenous people and took them back to England. And many of them were, of course, servants once they made it to England. This just went on, and it never stopped. It never stopped. It continued on. And there was a particularly heightened risk for indigenous women and children. Now, this act in particular was set because so many indigenous children were being stolen and kidnapped and taken from their homes and put into a foster care or into the adoption system or through private adoptions and adopted by people who were not indigenous people. So it became a huge commerce, and it was a huge issue where these children were just being taken. And of course, that's the future of the tribes. So because of that, finally, this act was passed, and it was passed in order to try to protect indigenous children. Indian children, again, is what they are being called legally. So this is specific to any child that is an indigenous child in the United States. There are special protections in place to make sure that if a child is being adopted or fostered in another place or removed from a biological family, that the movement is correct, is proper, and is not being done against anybody's will. That's the intent behind this statute. Now, there have been many people, and I've worked on ICWA cases where people are wanting to adopt a particular child, and the child is indigenous, and so they have to go through the tribe, they have to go through ICWA, and it's a lot of work, it's a lot of paperwork, it's a lot of hassle. But those extra steps were needed in order to prevent the sheer quantity of the children that were being taken. So it is a hassle, it is a pain, but it is a necessity that we have to have. So I have a very dear friend who just recently adopted a child and went through this process, and it's a huge headache. But, her family was like, it doesn't matter how much work it takes, it's worth it. And they went through the process, and he is adopted and have a very, very wonderful, amazing family. So wonderful story. All right. So let's take a look here. Again, this is put into place specifically to protect indigenous children. So the act is to establish standards for the placement of Indian children to foster or adoptive homes to prevent the breakup of Indian families and for other purposes. So I'll take you through just the beginning piece and how the federal law defines different categories and different terms involved here. So, be it enacted by the State and House of Representatives of the United States of America and Congress assembled that this act may be cited as the Indian Child Welfare Act of 1978. Section 2, recognizing the special relationship between the United States and the Indian tribes and their members and the federal responsibility to Indian people, the Congress finds 1. That Clause 3, Section 8, Article 1 of the United States Constitution provides that Congress shall have the power to regulate commerce with the Indian tribes. And through this and other constitutional authority, Congress has plenary power over Indian affairs. 2. That Congress, through statutes, treaties, and the general course of dealing with Indian tribes, has assumed the responsibility for the protection and preservation of Indian tribes and their resources. 3, that there is no resource that's more vital to the continued existence and integrity of Indian tribes than their children, and that the United States has a direct interest as a trustee to protecting Indian children who are members of or are eligible for membership in an Indian tribe. 4, that an alarmingly high percentage of Indian families are broken up by the removal, often unwarranted, of their children from them by non-tribal public and private agencies, and that an alarmingly high percentage of such children are placed in non-Indian foster and adoptive homes and institutions. And 5, that the states exercising their recognized jurisdiction over Indian child custody proceedings through administrative and judicial bodies have often failed to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing in Indian communities and families. All right, that was Section 2. Section 3. The Congress hereby declares that it is the policy of this nation to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families by establishment of minimal federal standards for the removal of Indian children from their families and the placement of such children in foster or adoptive homes, which will reflect the unique values of Indian culture, and by providing for assistance to Indian tribes in the operation of child and family service programs. Section 4, for the purposes of this act, except as may be specifically provided otherwise. And then they go into the terms. So let me walk you through their different terms that they're setting out specifically regarding this. So the first piece, a child custody proceeding shall mean and include foster care placement, which shall mean any action removing an Indian child from its parent or Indian custodian for temporary placement in a foster home or institution or the home of a guardian or conservator where the parent or Indian custodian cannot have the child returned upon demand, but where parental rights have not been terminated. Again, we're just getting into the definitions here that they're using under the statute. 2, termination of parental rights, which shall mean any action resulting in the termination of parent-child relationship. 3, pre-adoptive placement, which shall mean the temporary placement of an Indian child in a foster home or institution after the termination of parental rights, but prior to or in lieu of adoptive placement. And 4, adoptive placement, which shall mean the permanent placement of an Indian child for adoption, including any action resulting in final decree of adoption. Such term or terms shall not include a placement based upon an act which, if committed by an adult, would be deemed a crime, or upon an award in a divorce proceeding of custody to one of the parents. So that's our first step. Can bump to the left. Yes, thank you. I'm so glad you told me. There we go. We got it. Okay, so there we go. Yep. Am I centered? Is that better? Mm-hmm. Got it. Got it. Yep. Am I back to center? Good. Okay. Woohoo. All right, we're good. All right, so let's go through again, and I'm just going to go through the different terminologies here. Number 2, extended family member shall be as defined by the law or custom of the Indian's child's tribe, or in the absence of such law or custom shall be a person who has reached the age of 18 and who is the Indian child's grandparent, aunt or uncle, brother or sister, brother-in-law or sister-in-law, niece or nephew, first or second cousin, or step-parent. So that's extended family. Number 3, Indian. Indian means a person who is a member of an Indian tribe or who is an Alaska native and a member of a regional corporation as defined in Section 7 of the Alaska Native Claims Settlement Act. Number 4, Indian child means any unmarried person who is under the age of 18 and is either A, a member of an Indian tribe, or B, is eligible for membership in an Indian tribe and is the biological child of a member of an Indian tribe. 5, Indian child's tribe means A, the Indian tribe in which the Indian child is a member or eligible for membership, or B, in the case of an Indian child who is a member of or eligible for membership in more than one tribe, the Indian tribe with which the Indian child has the more significant contacts. 6, Indian custodian means any Indian person who has legal custody of an Indian child under tribal law or custom or under state law, or whom temporary physical care, custody, and control has been transferred by the parent of such child. Indian organization means any group, association, partnership, corporation, or other legal entity owned or controlled by Indians or a majority of whose members are Indians. A, Indian tribe means any Indian tribe, band, nation, or other organized group or community of Indians recognized as eligible for the services provided to Indians by the Secretary because of their status as Indians, including any Alaska Native village as defined in Section 3C of the Alaska Native Claims Settlement Act. 9, parent means any biological parent or parents of an Indian child or any Indian person who has lawfully adopted an Indian child, including adoptions under tribal law or custom. It does not include the unwed father, where paternity has not been acknowledged or established. 10, reservation means Indian country as defined in Section 1151 of Title 18 United States Code, and any lands not covered under such section, title to which is either held by the United States in trust for the benefit of any Indian tribe or individual, or held by any Indian tribe or individual subject to a restriction by the United States against alienation. Do I use the wording Native American or Indigenous people? You know, Hazel, it depends. I think that's a question that is best asked of whomever you are speaking to. It really depends. I think some places the term Native American is fine. Other places it's offensive. Some places Indian is fine, or Indian American. Almost everywhere I've heard Indigenous is okay, but that comes and goes as well. So that's definitely one of those questions that you kind of need to ask of whomever you're speaking to. And then just kind of making it pretty clear that, you know, whatever it is that is the best thing, let me know. That's a lot of times Native, right. I mean, again, it will depend on whom you're talking to. But the fact that we're even asking, I think, is so important. I think to ask what the preference is. You know, what is your preference? I think that's good for any kind of race. I think, you know, we kind of get into a rut of calling particular groups of people by particular names without asking, like, hey, are you part of that group, first of all? And then if so, what would you prefer? What's your preference? Always best to ask, absolutely. Yes, the word Indian is, I have to say, across the board, the most, in my experience, the most offensive, but the one that's used so much legally. There are many terms that are used in the law that I find extremely offensive, but are necessary to use. And yes, Indigenous, exactly, Kristen. That I would say is that's my personal preference in reference to my own background. But you know, even on my own birth certificate, there's a category for by race that is a word that is incredibly offensive, but it's a legal term. So that's the word that I was called. So sometimes that just happens. All right, number 11, secretary means the Secretary of the Interior. And 12, tribal court means a court with jurisdiction over child custody proceedings and which is either a court of Indian offenses, a court established and operated under the code or custom of an Indian tribe, or any other administrative body of a tribe which is vested with authority over child custody proceedings. To the right, to the right. There you go. So that's it for the definitions here. Yep. I'm in a little different spot, everybody, so it's harder to keep us on. So the next piece, I will just go and give you a brief view. So Title I goes actually into the custody proceedings and sets those out. I'm going to be careful to keep us centered here. Voluntary parental termination is covered in here. Next, we've got adoptive placement in any of the Indian child, any of the Indian children is included in this section of petition if you want to have the child returned. Removal from foster care is included in this piece. Moving on, the next part, jurisdictional issues here under the U.S. Code, state and Indian tribe agreements here as well. And then we've got where we have an improper removal of a child. What happens in emergency removal of a child? If you've ever done any juvenile law work or been involved in that process, you know that we do have emergency removals when a child is in trouble. Here's when the effective date was set out. 2, we've got Indian Child and Family Programs. That was set up as part of this act as well. So they kind of set some parameters for that in funding. And then last, we've got Title III, which is the record keeping information, which can be one of the most frustrating pieces, actually, of this entire piece. At least as an attorney, I found it to be the most frustrating, but you do what you do. Record keeping and information availability and timetables. This is so incredibly important. You have to have in your final decrees, anytime there is a final decree involving an Indian child, there are certain elements that have to be included, no exceptions. They just have to be included if the child is an Indigenous child. So that is required by statute. That's what is set out here. Okay, so there you go, everybody. That's ICWA for you in a very quick overview, a quick understanding of how that works. So that is what I have. Can you please tell me what this is called? My uncle was an adoptive. Yes. So this is called the Indian Child Welfare Act of 1978. And this is the actual name of it. And it's 25 USC 1901 is the code section. This is a federal statute. So this is federal law here. So you find it right there. So anytime there is an Indigenous child involved in any kind of a custody or adoption, foster care, removal, those kinds of things, ICWA will attach. It will come into play. It can be mutually agreed upon. The tribes get involved. The leaders in the tribes can get involved. What I found in my experience was there's usually a designated person within the tribe that's the go-to person. So if you're calling in and saying, hey, we've got an ICWA situation here in whatever state you're in, they will transfer you to whomever deals with their ICWA cases. And that'll be the point person. And so that's the person that you contact and get information from and send information back and forth to. So the tribes tend to have someone specifically for that role, in my experience. I've not worked with all the tribes. I've only worked with a few tribes, but that's what I have experienced. They will have a point person to go to in order to get the paperwork done that needs to be done. So, and sometimes the tribes will kind of not necessarily fight, but there will be some friction between two different tribes. And so that can kind of get frustrating where you're like, wow, I don't, which one am I supposed to go with? So that's when you're like, Your Honor, I'm not sure what you want to do here, but kind of take care of it. But, you got to do it. We've got the rules in place now, and I think that they're very valuable. There was a case in front of the Supreme Court recently regarding whether or not certain pieces of this were constitutional, and they were held to be upheld. So ICWA was kept in place. Lots of things were set out as well. Can you move the highlighted paper to the left? Let me see. Here we go. Let me see if I got that. Is that better? Maybe that's better. Better in place. Yep. Profound yet troubling. Oh, good to know legal words like yes, exactly. Oh, good. There you go. There were personal information of judges' clerks. Oh, okay. Thank you. Oh, you're welcome. Yes. People of the earth, the land, or the land of the dawn. There's lots of different ways, for sure. It's such a huge critical part of the history of this country and how our laws were made. I mean, when you go through the history of it, the Articles of Confederation, lots of those things, all of those, all set in place and influenced and a part of different indigenous cultures. So the influence is just huge. And if you know anything about Benjamin Franklin, you know that he was a huge fan. He was so interested in the indigenous tribes and the ways of that were so different than what he knew and understood. He tried to incorporate as much of that as he could into his work. So it's a very interesting area of the law, and it needs attorneys, it needs paralegals, they need as much help as they can possibly get. Incredibly underfunded and not spoken about enough, for sure. I personally don't mind Native being called Native myself. That doesn't bother me. In my family, that's a term that we use comfortably. So, but again, not everybody, everybody's a little bit different. So it really is up to, it's up to the individual. I have other family that would be extremely upset if you use that term. So there's just, it depends. It even varies within families too. So prefers Native as well. Yes. And I think too, part of it's like what you grow up with, what you're used to, versus also, your identification. I think as you get older and you find out more about your family tree and your tribes that you come from, I think you kind of develop a different sense as well of how you want to be identified. So it's a fascinating area of the law, everybody, for sure. You willing to talk about how you feel about Thanksgiving? For me, I think I find it fascinating, and because I am so mixed, I have so many relatives on both sides of it that I can see both sides of it. And so I think anytime we can express gratitude and thankfulness for, being here, I think is good. I think that's always a great celebration. But I think it would be a miscarriage of justice, and it would be incorrect to not truly understand that there were people living here before people came, and those people were terribly harmed. And I think that's just a basic historical fact that has to be understood. So that's one of my hard points that I just am not, I do not bend on. If there is no way to be able to look at the history of the United States without starting at that very, very important piece. That's where it starts. So very important, absolutely. So I think it's good to remember that. I think Thanksgiving is a great time to remember the indigenous tribes and to take a moment and acknowledge where they're at right now. And I live very close actually to a reservation. And so I think it's important, every single day to have some acknowledgement, but we're busy people. And I think Thanksgiving is the perfect time to take a moment and just remember what has happened to an amazing group of people. So yes. I mean, truly, once you can really look at the history, and the true history of the tribes, and I'm sure every state has tribes somewhere within your state. And so, I happen to live in an area with a lot and a huge, very rich history. But, I had done a post once going through, out of our 50 states, 26 had native names or indigenous names. So our language, our boundaries, all of those things it's so interwoven together. So I think it's important to note how spectacular this particular time in our history was. Spectacular good and spectacular awful. So both of those things, I think it's worth noting. Wonderful idea. Yes. Oh, absolutely. Cozy and Cray. I think it's important. And, a lot of people are not familiar with ICWA and aren't familiar with how it works until something happens and it gets pulled up. But I think it's so important to note that there are protections like this that are supposed to be used. They're supposed to be in place. So 2 big tribes in your area. Lovely. Yes, that's fantastic. Right next to a major part of there you go. Yeah, there's so much history there. In Indiana. Okay. Oh, absolutely. Seminole. Yes, absolutely. In Florida. Yeah, it's very interesting. Been dealing with ICWA for 2 years. Oh my gosh. Yes, it's a labor of love. Truly, it is a labor of love in the purest definition. It is a lot of work, but so needed. And the history of it's fascinating. If you ever have a chance in everyone's extra time, I'm sure, to look into how much time and effort and work it took to get this passed was amazing. And again, it wasn't passed until the late 70s, but it's a fascinating story. Yes, with Navajo. Yep. It's amazing. Well, if you think about it, there's got to be, throughout all over the United States. It's just hand in hand. There's no way to separate the United States and the indigenous people or the tribes from each other. There's no way to truly talk about one without the other. They have to go together. That's how it came about. So I think that's very important. So that's all I've got for our special that I can suggest. I don't have any off the top of my head that I would necessarily suggest. Honestly, the first thing that comes to mind is I found, and this, you're probably going to make fun of me for this, but if you go online, you can actually pull up the Arizona versus Navajo Nation case, and you can listen to the oral arguments in front of the Supreme Court. They're not too long. They're only about 90 minutes long, and you can hear each attorney from both sides arguing about it and talking about the history of the Indian law in the United States and having the justices ask questions. In particular, Justice Gorsuch is huge into Indian law. That's one of his special areas that he really focuses on. So he has a lot to say about that, and in fact wrote the ICWA opinion. So this is not the ICWA opinion, but I think this is a great case. If you are interested in learning more about it, legally, that's where I prefer to go. That's just how my brain works. But I'm sure there are other books and documentaries out there that aren't as legally dense as this, but I would recommend that. There's a great website called oye.com or .org, and you can go on there and pull up any case that was argued in front of the U.S. Supreme Court after a certain period of time and listen to them. But the Osage people, yes, very, very good. We love that. Thunder from the Mountains is a good book. Okay. Ooh, that sounds great as well. Yes. Well, it's a story of the U.S., so I think it's important to know. But thank you. Oh, good, everybody. Well, hopefully this was informative for everyone. You maybe picked up something you didn't know about before, or learned something new, or found out something new, hopefully. But this is a very fascinating area of the law, and it needs a lot of attention. So Prairie Lotus, really, I have to say, I think just recently there was a special, I think it was Arthur on public television that did a special Thanksgiving. Now, if you're looking for kids, I think that's an exceptional one. I do not recommend the Charlie Brown Thanksgiving, first of all. Oh my gosh. Yes. So, but there are some great pieces in there. But I will go ahead and sign off for tonight, everybody. But before I head out, I do want to say, just as a quick view, there's lots going on tomorrow, so I don't know when I will be back on exactly. But of course, my pleasure. But for the next live, everyone, look, I did print out, I have the transcript from Mr. Trump's testimony in New York. So that will be my next live. I will take you through what actually happened in court. So that will be my next one. I will let you know when I'll be back up again. I probably will be the next couple, if I do come on, I will be just showing hearings. I did do the hearing with Fani today, so I may show a couple more hearings, but I will make an announcement before I do the live going through this transcript, just to make sure everyone knows. I typically go live at 7 o'clock Central Time. But I'd like to start to do a mid-morning live as well, a shorter one where I'm taking you through actual hearings. So I've got a list of hearings that I would like to kind of go through and explain how they work and so on. So I may be starting to double up pretty soon doing that. So I will make sure and let everybody know when that starts to happen, but you'll need booze. Oh my goodness. Yes, but I wish everybody a wonderful Thanksgiving. And if you see the Macy's Day Parade tomorrow, that's one of our family's traditions for sure. So we will be all about that, and the pumpkin pie going on and all of that. So it's a very fun time. Oh, for wine for you. Excellent. We love that. So have an amazing night, everybody. Best of luck, and enjoy time with your family or by yourself. Sometimes that's the best way to celebrate Thanksgiving, for sure. But happy Thanksgiving, everyone. And thank you for joining me tonight. Always a pleasure. I will be back again very soon, everyone. So have a great night and happy Thanksgiving, everyone. Take care.